Ladies and gentlemen, the subject of what I'll be discussing today is the recent Supreme Court decision in the Heller case, District of Columbia versus Heller, the D.C. gun case, as it's generally known in the media. First question I'd like to ask of the audience, how many people have actually read the opinions in that case? Okay.
Including the dissents?
How many people have read the opinion, the majority opinion at least, in the Heller case, the D.C. gun case? So we have actually two people who have read it. Okay, that's good. Because I'll try to give you some actual language out of the case as opposed to simply talking about the general principles. Now, for purposes of an analysis here, I want you to keep something in your mind, which is what's called a Venn diagram of a constitutional right. And the circle, the black circle, represents all the possible behaviors, physical behaviors, that you can imagine involving an individual with a firearm. Anything an individual could do with a firearm falls within this black circle. Some of that behavior can be made criminal. That's the little red part. And it can be prohibited and punished. Some of it can be subject to civil liability. Person is shooting a gun at a gun range, commits an act of negligence, hurts someone else. He can be brought into a civil court and sued, generally speaking, for monetary damages. The green area is the area of regulation. The big word. Covers almost anything else that the government might do, from licensing to efficiency tests. Are you competent to use this firearm? Whatever. And what's left is this white area called the right, which is not subject to any kind of control. It's the uncontrolled activity of the individual with a firearm. Now, it's pretty obvious that if these three colored sections expand, and especially the last section, the regulation section, expands to cover all of the white area, what happens to the right? It no longer exists, all right? Which tells you right away that there's some problem with the argument that rights are subject to regulation. So I want to keep that in mind when we talk about the Heller case. Because the question in the Heller case, or the question I would ask about the Heller case, is the Heller case, and particularly the opinion of Justice Scalia. He wrote an opinion for the majority of 5, Scalia, Thomas, Alito, Chief Justice Roberts, and, interestingly enough, Justice Kennedy, who was considered a swing vote, or maybe a liberal vote, or maybe more than a liberal vote. And then you had, of course, the 4 real liberal leftists on the other side. Scalia, the so-called constitutionalist, so-called believer in original intent, writes the majority opinion for these 5. And the question is, did that opinion actually secure the constitutional right to keep and bear arms? And my view of it, having read it too many times, it doesn't. In fact, the right of the people to keep and bear arms that Justice Scalia has more or less invented in his opinion is not only not the right of the people to keep and bear arms of which the Second Amendment talks, it's not even a right at all. It's this picture with the white part removed. All right? Now, I start off with a method of constitutional interpretation that he uses, because there may be method in madness and there may be madness in method. But the reality is, in constitutional interpretation, the method that is employed often determines the result. And there are a number of different methods that jurists and lawyers like to employ depending on how they want the result to come out. It tends to be result-oriented as opposed to objectively driven by some kind of scientific criteria, if you will. Now, Scalia's opinion is a classic example of how not to interpret the Constitution. The only ones that are worse are Breyer's opinion and Stevens' opinion, the dissenting opinion. They're worse. All right, but Scalia's is bad enough. And I think this is not really surprising, because this is how they ended up with Kennedy in the majority. Scalia had to write an opinion that Kennedy would sign on to. So this is really the opinion of Justice Kennedy, if you know what I mean. Right? Because if they hadn't gotten his vote, he would have gone the other way. The saving grace of it all is that most of what Scalia says is what lawyers call dicta. It's by-the-way statements that have absolutely nothing to do with the actual issue in the case. But the danger of those statements, especially when they come from the Supreme Court, is lower courts and lawyers in particular tend to take those words at their face value and tend to try to use them as if they were actual decisions of the court. And many times they get away with it. Quite often they get away with it. All right. Now, let's start with Scalia's method of interpreting the Second Amendment. This is a quote from his opinion. In interpreting the Second Amendment, we are guided by the principle that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary as distinguished from technical meaning. Normal meaning may, of course, include an idiomatic meaning, but it excludes secret or technical meanings that would not have been known to ordinary citizens in the founding generation. Right or wrong? Yeah, pretty much so. There's a certain amount that's correct, but there's a very important part that's wrong. All right? First thing you have to understand about technical meaning, that's another term for the meaning as specifically used in law, as opposed to a layman's meaning or general dictionary meaning. Now, the technical meaning of lots of terms in the Constitution is, in fact, the meaning that has to be used. I mean, give you a few. Law of nations. I guess that's the technical meaning. We talk about the law of nations, not dictionary meaning, right? The privilege of the writ of habeas corpus, obviously, right? Bill of attainder, ex post facto law, due process of law. Those are all highly technical terms, and they are certainly not meant to be taken in some layman's version, right? Now, the technical meaning may also be the ordinary meaning, if that was the way the word was used, ordinarily speaking. And even Scalia says that. He says, normal meaning may, of course, include an idiomatic meaning, but it excludes secret or technical meanings that would not have been known to ordinary citizens. Well, what about the ones that would have been known to ordinary citizens? All right? Okay. Pretty simple. Well, militia, if we're talking about the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of people to keep and bear arms shall not be infringed. Militia is one of those words that in the late 1700s had a technical meaning that was also its ordinary meaning. Because from the 1600s, 1630s approximately, through the time of the Constitution and the Bill of Rights, the meaning of that term as it was actually applied in the colonies and the independent states was to be found in literally dozens of laws. I've read them all. I hope I've read all of them. In every one of the 13 colonies. There were dozens of these things. All right. That gave the specific meaning of the term militia as the colonials understood it. And that became the specific meaning for constitutional purposes. Because how else are we going to interpret the Constitution except looking at the law as it actually existed at that time? No dictionary is capable of providing you with that definition. Go to a dictionary and see if it tells you what the composition, organization, arms, training, and disciplining of the colonial militias in the United States was. They don't give you that information, all right? So why is Scalia talking in this muddled way? And the answer is, well, he's trying to find an excuse not to study the controlling law of that period, so that he's not going to be bound in his decision by something that's outside of his ability to fudge, because we can look it up, all right? Method controls result. Next step. Scalia's entire opinion is based upon separating the two clauses in the Second Amendment. One he calls the prefatory clause, a well-regulated militia being necessary to the security of a free state. Stop. The other he calls the operative clause, the right of the people to keep and bear arms shall not be infringed. All right? And Scalia says, logic demands that there be a link between the stated purpose and the command, but apart from that clarifying function, a prefatory clause does not limit or expand the scope of the operative clause. In other words, maybe we don't have to pay attention to those first few words. The reality is that right or wrong? Wrong! Oh, it's absolutely wrong. What was the rule in the 1700s when the Constitution was written with respect to clauses of this type? The rule was, and I quote from Thomas Rutherford, a book called Institutes of Natural Law, which after Blackstone's commentaries was probably the most popular law text used by the colonial lawyers, certainly anyone who was a student of law. And Rutherford said, if the reason of the law is expressed in such clear and precise words as to leave no doubt at all about the ultimate effect that the legislature designed to produce or about the end which it designed to obtain, then the meaning of the law is to be determined by the reason of it. All right? And Blackstone repeats that in his commentaries. And what that means is, in the Second Amendment context, the meaning of the law, the right to keep and bear arms shall not be infringed, is to be determined by the purpose of the law, which is a well-regulated militia being necessary to security of a free state. All right? Follow this? So you can't separate the two, and the people at that time who wrote statutes, or Constitution being a statute after all, right? High-level statute, but a statute nonetheless, the people who wrote those documents wrote them with these rules of interpretation in mind. So no one at that time would have said, we can separate the prefatory clause from the operative clause. They would have laughed at any such suggestion. But they weren't sitting on the Supreme Court today. All right? Moreover, but now let's go to the Supreme Court itself. Has the Supreme Court itself adopted Scalia's point of view? All right? Because if you don't know anything about what the law was in the 1700s, he may have read some Supreme Court opinions. Well, I'll give you a few Supreme Court opinions. Wright versus United States. Anyone wants citations? I actually have them. All right. To disregard a deliberate choice of words and their natural meaning would be a departure from the first principles of the constitutional interpretation. We have to look at the words. Right? Marbury versus Madison. Famous case. It cannot be presumed that any clause in the Constitution is intended to be without effect. Right? Reed versus Covert. The Constitution is an organic scheme of government to be dealt with as an entirety. A particular provision cannot be dissevered from the rest. Williams versus the United States. In expounding the Constitution of the United States, every word must have its due force and appropriate meaning, for it is evident from the whole instrument that no word was unnecessarily used or needlessly added. Every word appears to have been weighed with the utmost deliberation, and its force and effect have been fully understood. Specifically with respect to a constitutional amendment, Hurtado versus California. We, the Supreme Court, that's a quote, we are forbidden to assume, without clear reason to the contrary, that any part is superfluous. United States versus Wong Kim Ark. I love this one. In interpreting an amendment, they were interpreting the 14th Amendment there, but interpreting a constitutional amendment, the condition and the history of the law as previously existing must be read and interpreted. What was the law previously existing on the militia? Dozens and dozens of these statutes, which Scalia never talks about. All right? Well, what is the operative part of the law, which he does talk about? All right? Black's Law Dictionary gives definition. It's that part of an instrument intended for the creation or transference of rights, or by which the main object of the instrument is carried into effect. Well, what's the main object of the Second Amendment? Now, the security of a free state. All right, a well-regulated militia being necessary to the security of a free state. It's the security of a free state that is the object, all right, for which a well-regulated militia is necessary. That becomes the immediate institutional means. We have to have this institution. Oh, by the way, that's the only institution the Constitution says is necessary for any purpose whatsoever. Doesn't say Congress is necessary, doesn't say the President's necessary, doesn't say the Supreme Court's necessary, doesn't say even the states are necessary. The only thing it says is necessary is a well-regulated militia, because the well-regulated militia is the people. All right? If we don't have the people, we have nothing. All the rest of this falls apart. Right? Okay. So the intermediate institutional means is the militia, and the ultimate instrumental mechanism is the right of the people to keep and bear arms. Right? The right of the people to keep and bear arms allows for the maintenance of the well-regulated militia, which is necessary to the security of a free state. So the main object is not the right to keep and bear arms. It's not even the militia. It's the security of a free state. And one would think that that being the case, that prefatory clause, as Scalia calls it, would be the most important part of this amendment to interpret first, because without knowing what that means, we have no conception of what the rest of it means. And we're certainly not in a very good position to effectuate the purpose of the amendment, which is the key. Why else is it there? All right. So why does Scalia's opinion rely on separating these two parts of the amendment? Is it so that he can invent a right of the people to keep and bear arms that is not necessarily related to the militia? Well, let's see what happens as we go into his opinion. Talking about the operative clause. First thing he says is that the right of the people to keep and bear arms is an individual and not a collective right. Right or wrong? Half and half. All right? It's half and half. Yes, every able-bodied individual has a right to keep and bear arms, so to that extent it is an individual right. But if you look at all the militia history of the United States, that was because there was a duty to keep and bear arms. They never talk in the sense of a right to keep and bear arms, and I mean never. It's a duty to keep and bear arms. If you didn't have that gun, you were fined, and if you didn't pay the fine, you went to jail if your property wasn't taken. There is no statute that I've ever seen in the colonial period that talks about a right to keep and bear arms. All right? Why? Because this right, which has a consequence of fulfilling your duty, I mean, the government could take away the gun from you if you had a duty to have it, right? That right was directed towards what? The well-regulated militia, right? In which every able-bodied man had to participate with his own firearm. So the individual right was an individual duty, but because it was exercised in this collective institution, it was also a collective right and duty. So it's both. Right? In fact, it's the exercise of the individual right that creates or manifests itself in the militia. So it's one is one side of the coin and the other is the other side of the coin. Now, Scalia then tells us what keep and bear arms means. And this is where it begins to get interesting when you to look at, I guess, the ultimate effect, if maybe he didn't design it this way, but certainly the ultimate effect. He says, the term arms was applied then as now to weapons that were not specifically designed for military use and were not employed in a military capacity. A lot of people think that's good, right? Because it covers, well, I don't know, shotguns, bolt-action rifle. I mean, you can run down this list. They may be actually military, or have been, but today they're usually not thought of in that way. But it's a rather devious way to kind of twist definitions to deprive individuals of access to military arms under the Second Amendment, because that becomes the consequence of it. Right? I mean, ask yourself, dealing with firearms, what firearms are non-military arms in the hands of irregulars and guerrillas? None. Absolutely none. I have a wonderful book by a guy by the name of von Drack, a Swiss militia colonel, who describes how air guns can be used in a resistance mode. Total Resistance is the name of the book. Air guns. All right. They all can be used. Right? So if the Second Amendment protects only truly non-military arms, that is, arms that aren't designed for military use, what arms really are left, if you think about it? Kind of an interesting question that isn't resolved in the opinion. Then Scalia says, well, from our review of the history and so forth, it is clear that bear arms did not refer only to carrying a weapon in an organized military unit. Notice again the separation, setting the militia to one side. Now that may certainly be true, that you can find things in the history of pre-constitutional period in which the term bear arms was used in a non-military context. But it's certainly not true in respect of the huge body of historical material in which exactly the opposite was true. So why isn't he talking about the huge body of historical material that relates to the Second Amendment? So he finally gives us the meaning of the operative clause, the right of the people to keep and bear arms. He says, the operative clause of the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation. This is another example of judges reading into the Constitution words and phrases that aren't there. The word confrontation doesn't appear in the Second Amendment. Doesn't appear anywhere in the Constitution at all. So what's it got to do with what we're talking about here? Well, he wanted that word so he can get to a different result. All right? To kill a dog, you first call it mad. You change the name of the thing, or you apply a label to it that's different from the one that's actually on the page. Well, what sort of confrontation might he have had in mind? If he were talking about the militia, what would be the confrontations we would think of? Well, look at the Constitution. Congress has the power to call forth the militia to execute the laws. That's one type of confrontation. Suppress insurrections. That's another type of confrontations. Repel invasions. That's a third type of confrontation. Or the one that Justice Story talks about in his commentaries, the only one that he talks about in relationship to the Second Amendment, to resist acts of usurpation and tyranny. Okay? So, confrontation can have a pretty broad meaning. But it's interesting that Justice Scalia doesn't give it a meaning. He never really defines it in his opinion. What he does say, though, this is a typical, on the one hand, on the other hand, of course, the right to keep and bear arms is not unlimited. Thus, we do not read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation. But actually, he doesn't tell us any sort of confrontation that he had in mind. So we have this blank. And if it's not unlimited, that is, if some of it doesn't fall into this area here, and he just told us it isn't, then is it a right at all? No. It becomes fascinating when you read these things and pay attention to what's in between the lines. All right? So we're left with a decision at this point, definition of the right to keep and bear arms, which uses a word that doesn't appear in the Constitution and that the court doesn't define. Are we better off or worse off than before we had this opinion? We're worse off because now he's using a word that isn't in the Constitution. All right? All right, now he goes to some Supreme Court precedents. The most important one they discuss is a case called United States versus Miller. I find the case of the United States versus Miller is a fascinating one for a couple of reasons. The first one is that Miller actually interpreted the Second Amendment correctly. It actually used references back to the pre-constitutional militia statutes as the basis of making its determination. And it's also interesting that ever since then, everyone who's attempted to interpret the Miller case has come up with the wrong interpretation. I mean, it's been probably the most misinterpreted case of the Supreme Court, at least in this area, that there is. Now, at this point, in his opinion, Scalia finally gets back to making a sort of an offhanded reference to the relationship between the prefatory clause, the militia part of the Second Amendment, and the operative clause, the right to keep and bear arms. He says there are many reasons why the militia was thought to be necessary to the security of the free state. When the able-bodied men of a nation are trained in arms and organized, they are better able to resist tyranny. The history that the founding generation knew showed that the way tyrants had eliminated a militia consisting of all the able-bodied men was not by banning the militia, but simply by taking away the people's arms, enabling a select militia or standing army to suppress political opponents. Which is true. What's interesting, though, is a couple of pages earlier in his opinion, Scalia says, in reference to nothing in the case, that Congress, in fact, has the power to create a select militia. So on one page he says Congress has the power to do the very thing that he says 2 pages later the Second Amendment was written to prevent. Obviously there's some level of confusion here. And this, I think, is the influence of the Kennedy wing of the court. Right? He had to write an opinion that would satisfy all shades of opinion, if you know what I mean. And as a result, it becomes incoherent because there's no direct line of argument that follows from A to B to C to Z. All right? Then he says, the prefatory clause does not suggest that preserving the militia was the only reason Americans valued the ancient right. Most undoubtedly thought it even more important for self-defense and hunting. What evidence is there that most thought this? What evidence is there that most Americans thought that the purpose of the Second Amendment was for self-defense and hunting? Is that what the Second Amendment says? No. And if I would take it, if most Americans thought that, and thought enough of that to put it in the amendment, then the Second Amendment would have said something about self-defense and hunting. Right? Okay. He doesn't suggest, Scalia doesn't suggest any evidence for this. This just comes out of the blue, out of left field. All right? So you ask the question, why? Why are we getting something of this nature? Well, because most Americans today think of the Second Amendment in terms of self-defense and hunting. We have large gun rights organizations that talk about the Second Amendment in terms of self-defense and hunting and never mention that prefatory clause. And most Americans never think about that prefatory clause because the vast majority of Americans have never had anything to do with anything like a militia in their entire lives and have probably never even read the Second Amendment carefully enough to notice the connection with that word. Right? So what Scalia is obviously doing is he is playing on this lack of education and basically prejudice on the part of even the gun rights people to give us an interpretation of the Second Amendment which obviously doesn't apply because the words are different. Right? This is the Supreme Court of the United States. This isn't some, small claims court. The Supreme Court of the United States. All right? In a case that was I guess for a newspaper level, in the legal press at least, this was one of the most important cases in 50 years. And this is the kind of opinion we get out of these people. Right? Well, what about the right of self-defense as a basis of the right of the people to keep and bear arms? Well, the Second Amendment is clearly not about personal self-defense, my self-defense or your self-defense. It's about collective self-defense, community self-defense, our being organized to defend all of us against them, whoever the them happens to be. All right? The reason a person under the Second Amendment is supposed to have a gun is to fulfill this duty to be capable of serving in the militia. In participating in the militia, though, he may never have a need to use that gun for personal self-defense. He may stand guard duty indefinitely, right? He may work in the supply service. He may be a clerk typist. He may never use the gun for self-defense. So what's the relationship there? Well, it's adventitious, if you will, right? Certainly not necessary. But if he happens to have the gun, which he should have if he's following his duty, then he could use it for personal self-defense. So although the right to keep and bear arms has nothing to do with personal self-defense directly, it operates to secure an implement that could be used for personal self-defense. Well, I have a baseball bat at home. I have a number of baseball bats at home because I play ball with the children. Right? I certainly could use those baseball bats for personal self-defense. In fact, I've studied some baton techniques, so I know how to do that. All right? But the reason I have the bat is not for personal self-defense. And my property right to possess the bat, this thing, if we had a bat circle, bat Venn diagram, my property right to keep the bat does not depend upon self-defense. All right? And you could use that analysis for any implement you can imagine. Right? Property rights and implements that can be used for self-defense are not based on the right of self-defense in the same way the right of the people to keep arms that could be used for self-defense is not based upon self-defense. It's based upon this other purpose. All right? And on the other side, imagine a society where private possession of a firearm was unlawful. But I happen to have one, and I justifiably defended myself. It would still be an act of self-defense, but they could prosecute me for having the gun. All right? So you see there's no necessary connection. Scalia is supposed to be the smartest man in the Supreme Court. How come I can figure this out and he can't? All right, well, I don't know. I don't know. I don't want to give a suggestion as to what the answer should be there. All right? But I leave that to you. Okay? All right, now we come to the interesting part about this case to me, because Scalia, Alito, Thomas, and Roberts are supposed to be advocates of original intent. It's Kennedy, Ginsburg, Breyer, Souter, and Stevens are the living Constitution people. Anything goes, all right? Now, Scalia then writes in his opinion, having gone through all of this business, which supposedly was an original intent analysis, and actually come to the wrong result, he asked this question. We now ask whether any of our precedents forecloses the conclusions we have reached about the meaning of the Second Amendment. Think about that. We've just gone through this analysis of the Second Amendment based upon the original intent, that is, what the Constitution actually means. And now we're going to ask if some later decision by the Supreme Court nullifies that. All right? That's just what he said. If a precedent conflicts with the original intent, the precedent controls, because he said forecloses. That's what the word forecloses means, right? So the precedent must be superior to the Constitution, according to Scalia. So the precedent can change the meaning of the Constitution. It's right there. This is the living Constitution doctrine coming out of Scalia. Well, let's see how well he understands the precedents of the Supreme Court. United States versus Miller, I mentioned that before, right? Famous case. It was in most of the briefs that were filed. They're all mentioning the United States in one way or the other, misinterpreting it or trying to interpret it. Here's what Scalia tells us about United States versus Miller. The judgment in the case upheld against the Second Amendment challenge, two men's federal convictions for transporting an unregistered short-barreled shotgun in interstate commerce in violation of the National Firearms Act. Right or wrong? Wrong. Absolutely wrong. The case arose on a motion to dismiss the indictment. There was never a trial. No one was ever convicted. In fact, after the case went to the Supreme Court, the two defendants absconded and were later killed. They were criminals. They were later shot to death, both of them, I think. Right. So there was never, he didn't even understand what happened in the case. Right. Then he says, the court's basis for saying that the Second Amendment did not apply was that the type of weapon at issue was not eligible for Second Amendment protection. The short-barrel shotgun, right or wrong? Wrong. They didn't decide, the Miller court did not decide whether a short-barrel shotgun was covered by the Second Amendment. It specifically said, we don't know. And we can't use judicial notice to determine it. Judicial notice is the court will take as true a fact that is universally known. The sun rises, well, I guess that's not really the fact, but you know what I mean. The sun rises each day. Eastern Standard Time is, an hour different from Central Standard Time or whatever. Facts of that nature. But they couldn't determine whether a short-barrel shotgun was a suitable firearm for militia use. Now, why was that? Well, the two defendants didn't file a brief in the case. The only brief came from the government. There was no evidence. It was a motion to dismiss. There was no evidence at all. There was nothing they could determine. So they didn't actually answer the question. What would have happened when the case went back to the trial court if the defendants hadn't fled, if they had been actually innocent or believed they were innocent? Their attorney would have introduced evidence showing that shotguns were used in the trenches in World War I. And that in fact it was notorious because the Germans had complained that under the Hague Convention the use of shotguns was outlawed. It wasn't something that was unknown. And these were the Germans who started using poison gas, as I recall. They were the first ones to use poison gas, but shotguns were too much for them. All right. But it wasn't an obscure fact. It certainly could have been proven. And the U.S. Army at that time, this was 1939, was issuing at least 2 types of shotguns. All right. So it could have been proven. It just wasn't proven in the case. All right. The Scalia apparently missed that point. All right. Then he says, Justice Scalia, had the court in the Miller case believed that the Second Amendment protects only those serving in the militia, it would have been odd to examine the character of the weapon rather than simply note that the 2 crooks were not militiamen. Oh, I like that use of the 2 crooks. Presumed innocent until proven guilty. These people were never proven guilty. They were apparently killed in some gang-related activity, but they were never proven guilty in this case, but he knew they were guilty. All right. Justice of the Supreme Court. Why would it have been odd? In the Miller case, the court examined the nature of the firearm because it presumed that every adult male was a member of the militia. That's why it quoted statutes from Massachusetts, New York, and Virginia saying so. All right? That's why it even discussed the short-barrel shotgun. Scalia then says, as for the text of the Miller court's opinion, that discusses none of the history of the Second Amendment. It assumes from the prologue that the amendment was designed to preserve the militia, which we do not dispute, and then reviews some historical materials dealing with the nature of the militia, and in particular the nature of the arms their members were expected to possess. Not a word, even emphasizes that, not a word about the history of the Second Amendment. So according to him, the history of the Second Amendment has nothing whatsoever to do with the colonial militia. Notwithstanding that the first 4 words are well-regulated militia. They had nothing to do with it. Okay. Have we all lost our minds here? I mean, I'm reading this. This is out of a Supreme Court opinion. Have we all lost our minds? Or does he expect that we have all lost our minds? Okay. Then he writes, Miller stands only for the proposition that the Second Amendment right, whatever its nature, extends only to certain types of weapons. Well, I don't know, that may be overbroad, but it's fairly clear that the court in the Miller case assumed that the Second Amendment would protect the possession of military type or military usable firearms. All right? Miller, in fact, uses the term firearms that have some reasonable relationship to the preservation or efficiency of a well-regulated militia. Well, that would be military-grade firearms. All right, so why aren't M16 rifles protected by the Second Amendment? They certainly would have some reasonable relationship to the preservation or efficiency of a well-regulated militia. But what we will see is that later on in Scalia's opinion, he says exactly the opposite. Those can be banned, and apparently he's happy that they're banned. Like Kennedy was happy that they're banned, and Scalia had to say it that way. Okay? So how does he evade this problem? I mean, he just quoted Miller. He said Miller is a good case, right? This is a precedent. So how does he evade this problem that Miller says if it has a reasonable relationship to the preservation and efficiency of a well-regulated militia, it's protected by the Second Amendment? He says, read in isolation, Miller's phrase, part of ordinary military equipment, could mean that only those weapons useful in warfare are protected. That would be a startling reading of the opinion, since it would mean that the National Firearms Act's restrictions on machine guns might be unconstitutional. Machine guns being useful in warfare in 1939, or 1914, or 2008, when this opinion was given, right? Now, why would that be startling? Why would it be startling to think that the Constitution might cause some statute to be declared unconstitutional? You see, this is again an example of flipping the thing on its head. Right? We have this statute over here, and it would be startling for us to read the Constitution to overrule this statute. Which is the head and which is the tail? Or which end of the horse are we talking about here? All right? Yeah, the statute has overruled the Constitution. Right? This is Scalia. This isn't Breyer. This isn't Stevens. This isn't Souter. This isn't Ginsburg. This is Scalia. Right? Why should that be startling? In fact, if the court in the Miller case had had the evidence in front of it about World War I, it would have found the short-barrel shotgun was protected by the Second Amendment, and therefore the National Firearms Act was unconstitutional because it covered short-barrel shotguns, as well as machine guns. All right? Scalia goes on. He says, "We think that Miller's ordinary military equipment language must be read in tandem with what comes after. Ordinarily, when called for militia service, able-bodied men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. The traditional militia was formed from a pool of men bringing arms in common use at the time for lawful purposes like self-defense. In the colonial and Revolutionary War era, small arms, weapons used by militiamen and weapons used in defense of person and home were one and the same. We therefore read Miller," that is we, the court in Heller, "we therefore read Miller to say only that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barrel shotguns." Shall I read that again? The Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes, such as short-barrel shotguns. Why don't I have a short-barrel shotgun? Because there's a law that bans it. You follow this? You don't have to be a professor of logic to see the circle in this, right? But my view is a passage like this gives nonsense a bad name. Pre-constitutional, read the statutes. Pre-constitutional militiamen did not bring from their homes to militia service firearms they possessed as personal property. I mean, they did. He's right about that. They did, all right? But those firearms were what? They were of the same type that the armed forces used. There's no question about that. Most of them were the flintlock French or English muskets, a lot of them taken from the French in the French and Indian War. There was no distinction. There was no distinction. There was no distinction, all right? The arms supplied by themselves, as Scalia says, and in common use at the time for militia service were military-grade firearms. And the way to prove this is to look at the militia statutes of that time. And in many instances, they specifically say, you bring a gun, but your captain has to approve this for service. Why? Because it had to fit a certain pattern. Usually they had to have a bayonet attached or whatever. I mean, all these considerations were military-related considerations. The idea was to have the militiamen armed with firearms as serviceable for military use as possible. Now, typically, the firearms used by the militiamen and the armed forces in those days were smoothbore muskets. Very common. But militiamen, in many instances, also carried rifles, which was superior to the arms that the armed forces had. At least they were more accurate. Now, the arms that the militiamen possessed from militia service, Scalia is correct, they were the same ones they used for personal self-defense. But it was because people used for personal self-defense the arms they had for militia service, not because they used for militia service the arms they had for personal self-defense. All right? Try to get your history straight. Often, in fact, a man might have only one firearm. If he had to provide it himself and he was poor, he was a farmer, he might be lucky if he could afford one. And if he couldn't, actually the town would get him one. If he was poor enough, they'd provide him with one. But it was typical that they only had one. And that one was required by law to be what? Suitable for self-defense or suitable for militia service? Suitable for militia service. I don't have to be giving this. We know the answers here, okay? So cutting to the bottom line here, what's Scalia's conclusion? He says that Miller holds that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens. Well, then I guess if the politicians can ban certain types of firearms, and I as a law-abiding citizen would then not typically possess that firearm because I'm abiding by the gun ban, I like Charles Schumer's statute, I'm abiding by this, then I guess the Second Amendment would not protect me and I couldn't challenge the gun ban. That follow? Does in this opinion. Right? And if you don't believe that conclusion, look at the short-barrel shotgun that was involved in Miller, subject to the National Firearms Act, which Scalia says would be startling to believe could be unconstitutional. Why don't we have short-barrel shotguns sold in every gun store? What's a short-barrel shotgun? It's a shotgun that's an angstrom unit less than 18 inches long in the barrel. No, literally, if the BATF could measure an angstrom unit and they found your shotgun was an angstrom unit less than 18 inches long, that would be a prohibited NFA shotgun. All right? Well, angstrom unit is 1 to 10 to the minus 8 millimeters, right? Not very much. But that's the way the law reads. If it's shorter than 18 inches by any amount, it's illegal. Well, you're going to tell me that a 17-inch shotgun isn't a perfectly good self-defense gun? 16-inch shotgun? You can have 12-inch in a car. There used to be a gun called the Auto Burglar. Remember that one? It was about 12 inches long, came in 20 or 12 gauge. Must have been something to fire in 12 gauge. With no stock, just a grip. And I guess the idea was you kept it there on the seat, right? In the Auto Burglar gun, right? Banned. But there was a time when it typically was owned by law-abiding citizens. What's the difference? A statute intervened. And Scalia tells us the statute having intervened, the Constitution doesn't apply. Well, he isn't content to give us just that. Oh no, Kennedy was whispering in his ear on this one, I'm sure. This is where we hear Justice Kennedy talking from the shadows, right? Scalia says the right secured by the Second Amendment is not unlimited. They love that phrase, the right is not unlimited, the right is not unlimited. Because if it's not unlimited, they can say whatever they want about it. Okay? Although we do not undertake an exhaustive analysis today of the full scope of the Second Amendment, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualification on the commercial sale of arms. And to make it absolutely clear that he's accepting everything that's out there in the world of gun control, he says, we identify these presumptively lawful regulatory measures only as examples. Our list does not purport to be exhaustive. If you want the exhaustive list, you call Charles Schumer. Right? You call the Brady campaign. You call George Soros. He's got the exhaustive list. Right? They're now drawing up the legislation, right, to have this enacted in the next session of Congress. All right? All right, there you go.
So it doesn't apply to some people, many places, and most weapons.
Yeah, that's right. Well, I don't know. I always thought that the Bill of Rights, the doctrine of the Bill of Rights in constitutional adjudication was that if I have a statute that seems to violate one of the rights protected by the Bill of Rights, that statute is presumptively unconstitutional, which means that the government now, well, the person defending it, because it could be a situation where it's a non-government party that's involved here, but typically the government now has to prove that the statute is constitutional, and if the government's proof doesn't rise to a certain level, that's the end of it. I can simply sit back and say nothing, and I can still win. Scalia has now told us that with respect to the Second Amendment, the only amendment that talks about a right being necessary to the most important thing to which the Constitution is directed, all of these statutes are presumptively constitutional. So with respect to the Second Amendment, he has turned upside down the law of judicial review. This is the great victory. All right? Now, I've read the Constitution a few times, and I have never found the word sensitive places as a basis for the powers of Congress or a state or anything. I mean, the word sensitive places doesn't appear there. I've heard about regulating commerce, I've heard about taxation, but sensitive places doesn't appear. So what is this laws forbidding the carrying of firearms in sensitive places? And notice it's sensitive places such as schools and government businesses, not just schools and government. There may be other sensitive places. We don't know what that is. I guess that's one of those things that you intuit. Right? But it leaves rather a large area for statutory draftsmen who are interested in gun control legislation, which would be presumptively constitutional. If they call the thing a sensitive place, he's already said that is probably valid.
Sensitive places, nonsense.
Well, all right, I give you this.
People are sensitive places.
Places, yeah, well, okay, so even his English isn't too good. The one I like here that's really rather open is the mentally ill. You know, they're talking about all these veterans coming back from Iraq that have some kind of post-traumatic stress manifestations from the combat situation over there, and I can certainly imagine that that's true. Right? All right. They're going to treat every one of these people as mentally ill. Right? They could be armed with an M16 in Iraq. They come home and they can't have a gun in their own homes because of their service. Thank you very much. Right? Here's another word, an open-ended word, undefined, left to who? The professionals. The professionals of the psychology profession. The people who write for the New England Journal of Medicine, and we know what its position is on gun control. All right? He's given them another opening here. And I like the last one. Laws imposing conditions and qualification on the commercial sale of arms. A lot of leeway there for preventing arms from getting into your hands if you can't buy them. Or it's very difficult to buy them. Or they've imposed such great license fees that the prices go up by a factor of 2 or 3. The interesting thing about the colonial period was, how were these folks supposed to get their guns? There was a statute that said within so many days, usually 30 days of the time you become 16 years old or the time you move into the jurisdiction, you have to have this gun. And they told you what type and the other equipment. How are you supposed to get that? Did you go to a government armory? No, they didn't have them. You went to the free market to buy them. One of the aspects of this Second Amendment right is the existence of the free market in which this material can be obtained readily. And now he's telling us that one of the things it doesn't protect is the methods for closing off the free market so it can't be obtained. Okay? Now, he then goes on to tell us, we also recognize another important limitation on the right to keep and carry arms. Miller case, referring to the Miller case, the sorts of weapons protected were those in common use at the time. We think that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. What's that? Yeah. It's whatever somebody in authority says is dangerous, or somebody in authority makes unusual by passing a statute so that lots of people don't have them, such as the short-barrel shotguns. All right? They become unusual by hypothesis. Right? And you as a law-abiding citizen wouldn't ask to get the unlawful, so you're covered by the other thing he said, right? Only the things that a law-abiding citizen would have. Right? Now we come to really what I think is the crux point. I don't know why he wrote this, because it's like a giveaway, the ultimate giveaway. It says, it may be objected that if weapons that are most useful in military service, M16 rifles and the like, may be banned, then the Second Amendment is completely detached from the Prefatory Clause. It's not a matter of it may be objected. Certainly it will be objected because it does it, right? It's obvious, right? But, as we have said, that is, Scalia has said, the conception of the militia at the time of the Second Amendment's ratification was the body of all citizens capable of military service who would bring the sorts of lawful weapons that they possessed at home to militia duty. It may well be true that a militia, to be as effective as militias in the 18th century, would require sophisticated arms that are highly unusual in society at large. M16s. Indeed, it may be true that no amount of small arms could be useful against modern-day bombers and tanks. Ask the Vietnamese about that question. See if they know the answer to that one. But the fact that modern developments have limited the degree of fit between the Prefatory Clause and the protected right cannot change our interpretation of the right. In other words, even though we're eviscerating the amendment by attacking its purpose, we have the power to do it, and there's nothing you can do about it. Nothing you can do about it. So we come to the real bottom line in this. If it isn't Scalia's purpose, it's certainly the effect of this opinion to make sure, through this construction of the Second Amendment, that no militia today will be as effective, relatively speaking, as militias were in the 18th century against the forces of usurpation and tyranny, which always tend to be the standing armies. Right? The usurpers and tyrants never hire militiamen. They already have a standing army working for them. Right? And why is this the fact? It's because public officials have made this category of firearms unavailable by passing statutes that violate the Second Amendment. Right? So the result is the Second Amendment can be violated because of the existence of statutes that violate it. Well, Yes or no? Is that the conclusion? All right, okay. I just don't want to think that I'm putting something over on you. Right? Yeah. And the reality is, if anyone looks at the gun control movement in this country, it's been going on for a long time, certainly since at least the 1930s. Public officials are aiming to set up a gun-free zone called the United States of America. Many people that have guns are the police, who are under their control, or the Army, armed forces. Right? These are the modern developments Scalia is talking about. All of this gun control legislation, which aims at what? Controlling guns? No, controlling people. Guns are a manifestation of freedom. So the Second Amendment tells us, well, regular militia be necessary to the security of what? A police state? A totalitarian state? A communist people's republic? And what's that word that's in there? Free. A free state. Oh, this is okay. Right? Yeah. And so what we see here is the original intent people, the constitutionalists. What have they done? They have provided a panoply, if you will, of excuses for gun control. And they have preemptively told us that even they will not find these new forms of gun control unlawful as long as they get enacted and people essentially go along with them. Right? So what did Scalia's opinion actually do for Heller? Actually got him a second lawsuit, because after Heller won, he went back to the D.C. licensing, the D.C. police, and they told him, number one, he couldn't have a semi-automatic pistol, and they told him, number two, that he had to have it disassembled in his home anyway. So he's gone through this now. He had filed another lawsuit, and they now amended that D.C. ordinance. But I still think there are problems with it, so he may have to go through a third rendition of this. What did it get him? It got him the right, maybe, to have a handgun of some kind under some circumstances in his house, suitable, maybe, for self-defense.
Never to leave that.
After asking permission.
After asking permission, after figuring out a way to get it into the house, right? Because again, that's right. We have a host of other questions here that we're going to decide. But this is the bottom line. He has this thing in his house, all right? And that's it. And for how long can he keep it in his house? No, only until they don't declare it unlawful. Only until they don't declare it in the same category as a short-barrel shotgun. Right? Because we've already been told a short-barrel shotgun. And what's the difference between a short-barrel shotgun and a handgun? The short-barrel shotgun has a longer barrel. Right? And it fires shot. Right? But basically, what's the real difference? All right? One has been banned, and one hasn't quite yet been banned. But they've already told us in the opinion that when handguns as a category fall under the same law that covers short-barrel shotguns, the Second Amendment, it would be, how was the phrase? It would be startling to interpret the Second Amendment to declare that invalid. Isn't that the word he used, startling? Okay. So this is what Heller has. He has a very limited temporal permission to keep a handgun until the appropriate Congress and President come into power to pass a statute banning handguns, or banning shotguns, or banning rifles, or banning the particular type of ammunition they don't want you to have, which might be almost any kind of ammunition. Who knows? Well, that's what he is now, but I'm predicting that at some stage the Brady campaign is going to start taking this language and say, well, certain kinds of, handguns especially, because their whole argument is handguns are used in crime. Right? Your typical 7-Eleven hold-up artist has a handgun. All right? So this is the argument. They become dangerous. All right? So we can. He already said that. Scalia told dangerous and unusual weapons. Remember that quote? They can be banned. All right? The Supremacy Clause. If Congress passes a statute, what was the National Firearms passed pursuant to? It was actually a tax statute. And that was because they didn't think that they had a Commerce Clause basis, because they were dealing in many instances with firearms where the transaction didn't cross the state line. Right? I might sell you the firearm in New York, and they didn't think at that time that they could reach that under the Commerce Clause, so they had to come under the Taxation Clause. And that transfer was subject to a tax, and then you had to register the transfer and get a tax stamp. And that was how they controlled it. Well, subsequently to that, you have all sorts of Supreme Court decisions which essentially say if the gun ever moved in interstate commerce, then the fact that the transaction we're looking at is occurring within one state is still subject to congressional regulation.
So what good is the state,
None. None. Let me give you the word. Zero. None. Nada. Okay? Why? Because of the Supremacy Clause, Article 6, Clause 2. If Congress can constitutionally pass a statute of the type of the National Firearms Act, then the fact that the state constitution of Maine said that you have a state constitutional right to have a short-barrel shotgun would be of no consequence, because even a state constitution has to yield to a valid congressional statute. Now, I don't say that congressional statute is valid. The National Firearms Act is invalid. Why? Because Congress's power to tax is for the common defense and the general welfare. The possession of a fully automatic firearm by a militiaman is part of the common defense as defined by the Constitution. Ergo, you cannot tax the possession of or transfer of such firearm for a militia purpose. Easy. Constitution says so in so many words. All right? But they passed the statute anyway. So now... The National Firearms Act? That was the Miller case. United States versus Miller. That was the challenge. And after that, all the lower courts said, well, Miller stands for the proposition that short-barrel shotgun is not covered by the Second Amendment. It's not a militia firearm. They gave this interpretation. All right, that's how it escaped. And it would have, as I said before, it would have been decided if Miller and the other fellow hadn't disappeared. If they had actually been innocent. Or, I guess they were using the short-barrel shotgun for criminal purposes because they had a history of having been engaged in gang-related activity. But the case never, that's the peculiarity of the Miller case. Because usually these things, as you know, Bob, you go up to the Supreme Court, they give you some ruling, you come back to the trial court if there's more to be done in the case, and then that ruling becomes the law of the case. And the law of the case in that situation was, we don't know whether a short-barrel shotgun is a militia firearm. So I, as the attorney for Miller, would have filed my motion to dismiss again and asked for an evidentiary hearing. And I would have subpoenaed some people from the Army and the National Guard and the Colt Manufacturing Company. I guess it wasn't Colt, Remington made them, right?
You could prove it out.
And I would have proved it. And I would have created a record. And then that same district judge, because remember, he ruled for me on nothing. There was nothing there, just a motion. He doesn't even give an opinion. He just says unconstitutional Second Amendment. That's it. Doesn't even give an opinion. I think he would have given me the same opinion now that I had the evidence. And then the government, which had a right to appeal a dismissal of the indictment directly to the Supreme Court, they would have taken it back, and the Supreme Court would have said, oh, well, now it's proven. Now the thing that we couldn't decide in judicial notice is proven. National Firearms Act's unconstitutional. Let him go. As startling as that might have been in 2008, that's what they would have done in 1939. Well, let me put it this way. When this thing came out, the first thing that was heard from the gun control lobby was, this opinion does not curtail reasonable regulation of firearms. That was their line. So all they had to do was take the magic language out of this opinion and either put it in the preamble of the statute or work it somehow into the operative clauses, and they get this result. This is the point of my drawing this diagram, right? We're back to regulation here, and once we say that regulation covers this entire area, we no longer have the right. And that's what they just told us in the Heller case. That in some way or other, using some kind of magic language or other, because he gave us 4 different phrases that can be used, and with the basis that whatever we enact will be presumptively constitutional, which is a new wrinkle here. All right? Now I, the fellow who's covered by this, am going to have to disprove the validity of this law. And that's extremely dangerous because if the police protection, let's take that as an example.
Gun control legislation because of what it said.
Well, they're using this as the rationale. I'm sure they had all those bills in the can, as they say in Hollywood. Right? I mean, the films had already been made. They were in the can. But they had, how shall I put it, Congress was afraid of new gun legislation. Yes. And most state legislatures were outside of Illinois. I mean, there were a couple of places where they had a left-wing control. But most state legislators were also not willing to go too far on the limb. Now the Supreme Court has said, oh, yes, it is. Everything that's out there now is good. We just told you that. It's all presumptively constitutional. And if you can pass these things, enough people lie down and accept them so that the guns then become the opposite of ordinary, right? They're not typically possessed by law-abiding citizens, then the Second Amendment doesn't apply to it. Well, my God, what more do they need? Yeah, you know what interests me about this, though? That's what I would expect. I mean, if people were sensible, you would have seen the biggest upsurge in gun purchases, especially the type, so-called assault rifles, especially the type that you think might be banned in an Obama administration or a McCain administration, because they're both about the same. Right? And what has really happened with the gun rights people? They get to sleep. Oh, we won! Right? It took us 40 years or 50 years, but we won. Did they win? No. This is the greatest disaster that ever happened to the Second Amendment. Oh, no, yeah, gun owners in America, I don't want to name the ones that we know. Okay. There are certain large gun organizations that have been taking credit for this as a great victory. There are some smaller gun organizations that have a more realistic view of the world, Larry Pratt being the leader of Gun Owners of America. That's true. That's right. Aaron Zellman. Right? What's the name of that? Jews for the Private Ownership of Firearms. Okay, there's another one that has a slightly different perspective on this, because I think he read the opinion carefully. Right? No, what I'm saying is the Supreme Court has said this, and as a result of that, you're going to get certain legislation out which the courts are going to uphold.
Which is the living Constitution.
Am I in control? I'm not advocating this. I'm telling you what's going to happen. We just did an examination. You have melanoma. You have 3 weeks to a month. Am I advocating this? I'm predicting it. Okay? I know you came from that other doctor, and he said you only had acne. That this was actually a good case. He could cure it. Wrong. This is melanoma. This is deadly. Now we have to start thinking about some way to deal with this.
So you're saying we are living in a living Constitution?
No, I'm saying that you got a lot of unconstitutional decisions coming out of a lot of, worthless judges.
Give us the humanist solution.
Huh? You can't change the Constitution because some moron makes a mistake about it. All right? No matter how many times they say the wrong thing about the Constitution doesn't change. But the reality is, if they're in the right position to say the wrong thing about the Constitution, then they can have deleterious effects on all of us, because a lot of people in this country treat them as authority figures. We don't have, how many people listened to Obama in that speech? He had 70,000 people in the stadium. When am I ever going to get 70,000 people to listen to this discussion of Heller? There's the difference. Not that I give myself credit, but you know what I mean. Anyone who would talk about this the right way, when is that person going to have a 70,000 person audience and on nationwide television? I think it's lesser. I mean, I kind of infringe on this space by, kind of just going into it, whereas I might abridge this thing by throwing it over. I think infringing, you have to do a lot less to infringe a right than to abridge it.
Stronger protection than
Right, stronger protection. And why? What's the preamble? What he calls the preamble. There's no preamble, it's one amendment. A well-regulated militia being necessary to the security of a free state. That's why, that's why they didn't want anything. Yeah, what Blackstone talked about the right of self-defense. Said the right of self-defense is a right that no government can take away. It's a natural right that no government can take away. The reason being, of course, that when it happens, the government can't be there to protect you and so forth, and so you go through that whole analysis. So, no, two aspects of this. As I said before, if you have a gun because of the militia duty, you obviously have an implement of self-defense, and there would be no question that you can use it. But if you have a baseball bat, you have a golf club, you also have an implement of self-defense. I think self-defense was treated as something that was, it was even above 9th or 10th Amendment considerations. This is just a natural condition of the human being, is self-defense. Right? Government has nothing to say about this. If you get into the implements of self-defense, can I use a tactical nuclear weapon to defend myself? No, because the spillover in other people who are totally innocent of the aggression is such that it would be unjustifiable, all right? So we can imagine situations where the implements could in some way be regulated because the consequence of their uses would spill beyond the self-defense area, the right of self-defense. All right? But that's not what this case is about. What this case is about is trying to bring us, or take us over here into what most people accept, at least the gun rights people accept, as a basis for having a firearm, self-defense. Right? And then forget the ultimate purpose here. And that allows them then to say, well, now you don't have a M16. Now we can ban all these extraordinary, unusual weapons. Now the National Firearms Act is valid. Now all the gun control is valid. Why? Because you can defend yourself in your home. You can have all of these regulations, but you still have the gun in the home to defend yourself. You know what this reminds me of? People probably don't remember this case. 1 second, get to you. There was a case called Stanley versus Georgia many years ago. Opinion written by Justice Marshall, Thurgood Marshall. And it was a pornography case. This fellow had pornography in his home that was banned in Georgia. And the Supreme Court had said that the states had the power, localities had the power, according to community standards, to ban pornography, right? Whatever that is. I know it when I see it, right? That was the way Justice White said. I can't define it, but I know it when I see it, all right? And the states had essentially local control. You can impose bans on pornography. So he had pornography in his home. And somehow or other the police got into his home, not in connection with the pornography, but they found it. And so they're lying on a table or something in plain view. And so they prosecuted him. The Supreme Court said, no, you can't do that. A man, even though this is illegal to have on the street in Georgia, you can't prosecute him for having the pornography in his home. But a couple of years later, they came out with a decision that said, yeah, but you can prosecute these people for trying to get it into their homes. All right, it's illegal, so they can't get it in. Well, this is essentially is a pornographic decision with respect to the Second Amendment. Just like pornography, you can have a pistol in your home, but that's as far as it goes, Joe. Outside of your home, we can control this thing any way we damn please. And there ain't nothing you can do about it. So there needs to be something we can do about it. And the sad situation is that the large gun organizations, who brought this case? Actually, it was the Cato Institute. It wasn't really a gun organization. It was Cato Institute. They financed it. But the big gun organizations put their oar in the water, too. And they're all claiming that this is a tremendous victory, and they're going to run around the country using this to limit.
Even Cato?
Yeah, I would say they are. Yeah, you get the remedy through state legislation. That's the only way to circumvent this kind of thing, is to keep the matter out of the court system by passing state legislation. I'll give you the example. If the state of New Hampshire passed a militia bill and said all the members, defines the militia the way it did correctly, Constitution says all members of the militia are going to be armed with a fully automatic rifle produced by the Ruger company up in wherever it is in northwest, right? And Ruger builds these things, and they all have a stamp, New Hampshire militia. I take it that's outside of the National Firearms Act, it's outside of the taxing power of Congress, it's outside of the Commerce Clause, and it's protected by the militia. What militia? The militia of the several states, that's what they're called, right? Can the court do anything about that? No. Can Congress do anything about that? No.
But if we have to import the guns from another state, then they could recall them.
They might try. Yeah, they might claim that was a Commerce Clause, Commerce subject regulation. Yeah, because the power of Congress with respect to the militia is to do what? To organize, arm, not disarm. See, the trick that they have here is they're disarming you as a single individual. All these statutes are directed to single individuals. If they attempt to pass a statute that says we're going to disarm the actual militia, they're in direct contradiction of their own power.
Be careful, they'll arm us with spoons.
Hmm?
We have to be careful, Congress will arm us with spoons.
Don't give them any ideas.
You know that, are you working for the Brady campaign?
Just warning you.
Well, I don't know, Soros might pay you for that idea. That sounds like a good one. No, listen, the bottom line on all of this is you have a criminal regime running at least the general government in Washington at every level in every branch. Some of these guys don't know any better, just like the people who worked for Don Corleone didn't necessarily know any better, right? Or worked for any mobster. They don't necessarily know any better. But at the top levels, they know precisely what they're doing. You saw it yesterday, $700 billion. Whose pocket that going to go into? All right, that's okay. These guys know just what they're doing. You go into the court system, and that court system is designed to maintain the power structure. Now, if there's a particularly egregious case, every now and then they throw a sop to the people. We protect this, we'll give you some. This is what this was. This was the sop that was thrown. Yeah, you can have a gun in your house for now, until we decide you can't have it, if you're smart enough to read the opinion.